Subcommittee on Health, Employment, Labor, and Pensions will come to order. Welcome, everyone. I note that a quorum is present. I ask unanimous consent that Representatives Suzanne Bonamici of Oregon, Pramila Jayapal of Washington, Johanna Hayes of Connecticut, Bradley Byrne of Alabama, and Ben Klein of Virginia be permitted to participate in today's hearing with the understanding that their questions will come after all members of the Health Subcommittee on both sides of the aisle who are present have had an opportunity to question the witnesses. But we welcome our colleagues to this hearing. Without objection, so ordered. The subcommittee is meeting today in a legislative hearing to receive on Protecting the Right to Organize Act, Deterring Unfair Labor Practices. Pursuant to Committee Rule 7C, opening statements are limited to the chair and the ranking member. This allows us to hear from our witnesses sooner and provides all members with adequate time to ask questions. I recognize myself now for the purpose of making an opening statement. Today, we're holding the first legislative hearing on H.R. 2474, the Protecting the Rights to Organize, or the PRO Act, a comprehensive proposal to strengthen workers' rights to organize and to bargain for higher wages, better benefits, and safer working conditions. This hearing will focus specifically on the provisions of the bill that prevent employers from violating workers' rights through coercion, retaliation, and delay. For generations, labor unions fueled our nation's prosperity, protected the health and safety of American workers, and supported a strong, strong, strong middle class. When union membership was at its peak of around 30% between the end of World War II and 1973, wage growth and worker productivity grew at nearly identical rates. But over the next 4 decades, as union membership declined, the link between rising productivity and rising pay was eroded. Between 1973 and 2017, worker productivity increased by 73%, but wages only grew by 12%, adjusting for inflation. This shift has undermined the financial security of workers and their families and contributed to the severe income inequality we face today. Yet, despite the proven benefits of strong unions, just 1 in 10 workers is currently a union member. That's a level not seen since the 1930s, just before the passage of the National Labor Relations Act. But American workers have not given up on unions, far from it. Support for unions is at a 4-decade high. According to a poll of workers across the country by researchers at MIT, 48% of non-union workers said they would vote to join a union. One major reason for the gap between worker enthusiasm and low union density is that toothless labor laws, more intense and more sophisticated employer opposition to unions, and relentless political attacks have dismantled workers' right to organize. The current system allows employers to unlawfully discourage, delay, or prohibit union organizing with near impunity. Even when our labor laws work as intended, employees are often left with hollow victories after months or years of appeals. Today, we will evaluate how provisions in the PRO Act would deter employers from violating workers' rights to form unions. The PRO Act would do this in 5 ways. Number 1, first, it establishes meaningful penalties for companies that violate their employees' rights. Incredibly, there are no civil penalties that can deter employers from violating workers' rights to organize under current law, no matter how repeated or willful the conduct. The PRO Act would authorize civil penalties for employers that retaliate against workers who seek to join a union. Second, the PRO Act would streamline procedures to guarantee swift remedies. If a worker is unlawfully fired for organizing, they may have to wait years before receiving recourse, and justice delayed is justice denied. The PRO Act would guarantee temporary reinstatement for workers while their cases are pending and would make National Labor Relations Board orders self-enforcing, like those of any other federal agency. Third, the PRO Act would ban employers from requiring employees to attend captive audience meetings. Fourth, the PRO Act would establish a mediation and arbitration process to encourage employers and unions to reach a first collective bargaining agreement. Under current law, even if a union wins an election, employers can stall at the bargaining table with minimal consequences. The PRO Act would effectuate the NLRA's original purpose of promoting collective bargaining. And finally, the PRO Act fosters transparency so employees know their rights under the law. Other federal law and employment laws require employers to post notices of employees' rights, like Title VII of the Civil Rights Act, the Family and Medical Leave Act, and OSHA. The PRO Act will similarly guarantee that employers notify employees of their rights under the law. This legislation is all about restoring workers' right to organize and improving the quality of life for workers and their families in communities across America. I want to thank our witnesses for giving us this time and expertise this afternoon, and I now yield to the ranking member, Mr. Wahlberg, my friend, for the purpose of an opening statement. Mr. Wahlberg, the esteemed Mr. Wahlberg.
Oh, keep it up. Madam Chairwoman, thank you. I appreciate serving with you on this committee, and we disagree on some things, we agree on plenty of things. And I would say today as well that our esteemed chair of the full Education and Labor Committee, as well as yourself and I, certainly agree on some things about the labor movement, the labor union, and the accomplishments that they've had. That has been a benefit to all of us who have been in the workplace, at whatever area of the workplace it has been. Organized labor has a long history in America, in the workforce of America, in its diverse looks and places in the workforce. Their early advocacy for fairness and decent treatment left an important legacy, and I say that sincerely. It saved lives, that have impacted benefits and futures for Americans and given an example, in many cases, to the rest of the world. But that legacy also is, as it's continued, unfortunately, to the modern labor movement, has appeared to have been abandoned or gone beyond need in many cases. And that's what we're discussing today, and it's a vital discussion. I grew up in a union household on the south side of Chicago. My father was a machinist and, in fact, tool and die maker and a union organizer. I remember seeing the buttons on his apron and on his cap of the Steelworkers Union. I saw that in my household, and upon graduating from high school, I went to work at U.S. Steel South Works on the south side of Chicago. Number 2 electric furnace. As a laborer, as a furnace worker, a ladle repairman, as a mold platform operator, third helper on the furnace, and as a hooker. And if you're a steel mill operator, you'll know what a hooker is. But that was my life. And I can tell you that there were parts of those jobs that I performed that were safer, benefits were better because of early work by my father and other union workers. But there are other things about that as well. The lessons I learned from my father and my own experience as a union worker helped shape my understanding of labor unions, both the good and the bad. Americans have the right to organize. I'll say that again. Americans have the right to organize and to join a union if they choose to do so. The United States law has protected this freedom for over 80 years. Outdated U.S. labor laws are in need of significant reforms. It's true. But those reforms should put workers, not union leaders, first. With all due respect, the sweeping legislation we are here to discuss today doesn't benefit workers. H.R. 2474 reads like a sweeping special interest wish list. Contrary to the statements of the bill sponsors, this bill fails to promote the well-being or success of American workers. Instead, the legislation grants unprecedented power to special interests at the expense of workers and employers. And it takes two. Among its many radical provisions, the bill requires employers to turn over workers' personal information, including their home addresses, cell phone and landline numbers, personal email addresses, and more. My workers aren't asking for that or wanting that, without workers ever having a say in the matter. H.R. 2474 will decimate workers' rights to privacy in order to satisfy union demands. The bill also bans right to work, or as I call it, employee free choice laws that allow workers to decide for themselves whether to join and pay a union, laws that have resulted in more jobs and higher incomes for workers, and in an effort to make it easier to create unions, the legislation contains a backdoor card check scheme that Congress deemed too extreme in the last time Democrats were in power. The scheme provides that in the event that a union loses an election, employers must prove they did not interfere in the election's results, a completely ludicrous and unworkable standard. If an employer is unable to prove they didn't interfere, that union is automatically ushered into the workforce without ever winning a secret ballot election. Union membership across the United States is steadily declining. They've failed to adapt with the changing economy, and the absence of transparency and accountability in their activities has left many workers disillusioned and dissatisfied. But instead of making necessary changes to better serve their members, union leaders appear to be exerting their political influence to call for radical labor laws like this one that will allow them to further consolidate power and bolster their own agendas. Rather than empowering unions at the expense of workers and employers, reforms to the National Labor Relations Act, NLRA, and the Labor Management Reporting and Disclosure Act, LMRDA, should improve union accountability and transparency. The union elections process must be updated to give workers expanded voting rights. It's the height of hypocrisy that Americans select their representation in Congress by secret ballot, and congressional Democrats select their own leadership by secret ballot, yet they seek to deny that same right to Americans selecting their representation in the workplace. Today's workers deserve better than what this extreme legislation has to offer. 10 years on from the Great Recession, and the American economy is achieving robust, record-breaking growth. Wages are rising while unemployment remains near record lows, and the number of job openings exceed the number of job seekers nationwide by 7 million. Workers have built this reality, spurred on by pro-growth policies like the Republican-led tax law and regulatory reform. Everyone sitting here on this dais is here because we prevailed in a debate over ideas back in our districts. We're here because our constituents decided we would be responsible enough and responsive enough to serve them. Congress may not be the most popular organization in America, but at least there are mechanisms in place for voters to change their minds and change their representation. Those same basic American values and principles should apply to everyone, including organized labor. Resistance to those basic values and principles deserve a thorough examination. And thankfully, that's what we're here to do today. And I commit myself to that effort, Madam Chairwoman, and I yield back.
Thank you, Mr. Wahlberg. Material for the hearing record, I remind my colleagues that pursuant to committee practice, materials for submission from the hearing record must be submitted to the committee clerk within 14 days following the hearing, preferably in Microsoft Word format, by 5 p.m. on May 21st, 2019, without objection. I will now introduce our witnesses. Mr. Richard Trumka. Mr. Richard Trumka is the distinguished president of the AFL-CIO. He was formerly the president of the United Mine Workers of America and a third-generation coal miner. Welcome. Mr. Jim Strauss is a former employee of the University of Pittsburgh Medical Center. Mr. Philip Samara is a partner at Morgan Lewis and Brokius LLP and former chairman of the National Labor Relations Board. Mr. Mark Gadsden Pierce is the former chairman at the National Labor Relations Board and currently the executive director and distinguished lecturer at the Workers' Rights Institute at Georgetown University Law Center. Welcome today. Thank you for being here. We certainly appreciate your presence and your time. We look forward to your testimony, and let me remind the witnesses that we have read your written statements, and they will appear in full in the hearing record. Pursuant to Committee Rule 7D and committee practice, each of you is asked to limit your oral presentation to a 5-minute summary of your written statement. Let me also remind the witnesses that pursuant to Title 18 of the U.S. Code, Section 1001, it is illegal to knowingly and willfully falsify any statement, representation, writing, document, or material fact presented to Congress, or otherwise conceal or cover up a material fact. Before you begin your testimony, please remember to press the button on the microphone that's in front of you so that it will turn on and the members can hear you. As you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow to signal that you have 1 minute remaining. When the light turns red, your 5 minutes have expired, and we ask that you please wrap it up. We will let the entire panel make their presentations before we move to member questions. When answering questions, witnesses, please remember to once again turn your microphone on. I will first recognize Mr. Trumka.
Chairman Wilson, Ranking Member Wahlberg, and members of the subcommittee, on behalf of the 12.5 million members and 55 unions of the AFL-CIO, thank you for inviting me to testify today. I want to thank House Education and Labor Committee Chairman Bobby Scott and his colleagues for his foresight they've demonstrated in crafting this important legislation. Gallup recently put the popularity of unions at 62%, a 15-year high. The Wall Street Journal reported that in 2018 was the biggest year for collective action in 3 decades. Teachers from West Virginia to Arizona, Google employees, workers in every sector and every region are embracing the transformational power that comes from joining together in common cause. MIT found that half of all non-union workers would join a union today if given the chance. That's more than 60 million Americans. So why haven't we seen a rise in union membership commensurate with this surge in approval, recognition, and desire? Well, the answer is clear. Our woefully outdated labor laws no longer serve as an effective means for working people to have our voices heard. The stated purpose of the National Labor Relations Act is to encourage collective bargaining. Yet in the more than 80 years since its passage, every amendment to the law has made it harder for workers to form unions. Today, union-busting consultants are paid tens of millions of dollars to deny workers a voice on the job. And once a union election is won, the same bad actors do everything in their power to undermine the collective bargaining process. Workers are forced to sit in meetings where the only item on the agenda is bashing the union. Pro-union workers are fired. Employers refuse to bargain in good faith. Some refuse to bargain at all. And far too often, the financial consequences for breaking federal law is virtually non-existent. This must change. The Protecting the Right to Organize Act will change it. Now imagine if when running for office, your opponent could force the electorate to listen to speeches urging them to vote against you. Imagine your opponent had the power to punish those voters if they did support you. Imagine that Congress refused to recognize your rightful election. And then imagine that once you finally were seated, you were denied the basic rights and responsibilities that come with that office. That's the grim reality that workers face today. They see it in a number of places: misinformation, reprisals, delays, threats. And after all of those obstacles are overcome, an outright refusal to recognize the election results. I've included several such examples in my written testimony. And that's why half of non-union workers want to join a union today, yet less than 12% actually have one. Why does it matter? Simply put, workers in unions bargain for higher wages and are much more likely to have health care and a pension. The union advantage is even greater for people of color and those without a college degree. Unionized workers have a real say in critical workplace issues like time off to care for a loved one, the deployment of technology, protection from discrimination. A happier, healthier, more upwardly mobile workforce is good for our economy as consumers have additional money to spend, local tax revenues increase, education funding is bolstered, inequality shrinks. It's a virtuous cycle upward, not downward. The union movement and all working people are hungry for pro-worker reforms to existing labor laws. The PRO Act would do many important things. Chief among them, provide more substantial relief for workers whose rights have been violated. Ensure a process for reaching a first contract once a union is recognized, and create a true deterrent so that employers think twice before violating the law. Something's happening in America. Workers are embracing collective action with a fervor that I haven't seen in a generation. It's time for our laws to catch up. It's time to make the PRO Act the law of the land. Thank you very much.
Thank you so much, Mr. Trumka. We will now recognize Mr. Staus. Welcome.
Madam Chair Wilson, Ranking Member Wahlberg, and members of the committee, thank you for the opportunity to testify today. My name is Jim Staus. I'm a part-time porter in Pittsburgh, Pennsylvania. I'm honored to speak with you today about the PRO Act. 7 years ago, I started to organize a union at the University of Pittsburgh Medical Center, or UPMC. I learned firsthand what workers face when they try to stand up for better wages and a safer working conditions. When I went to work at UPMC in 2006, I thought if I worked for the biggest employer in the city, I'd be able to provide for my family. If you ask my neighbors about good jobs, they say, try to work at the hospital. They pay well. But I quickly learned that things at the hospital were not what I pictured. UPMC is a $19 billion global entity. I still started at $9.60 an hour. I was surprised that I was making so little, but I thought if I just worked hard, things would change. So I went to work 5 a.m. each day and gave my best. My job was demanding. I had to carry 300 pounds of supplies per unit per shift. My job should have been performed with a power jack, but we had to use manual ones. We had no back braces either. I'm not a doctor, and I cannot prove that I got hurt from working without proper safety equipment. I can, however, tell you that I've had 2 knee replacement surgeries. I can also tell you that I could not make ends meet. I needed government assistance to put my food on the table for my family the whole time. One particularly rough winter, our water was shut off, so my wife and I had to melt snow to be able to flush our toilets. Still, I enjoyed my job. I liked helping people recover from illness and injuries. In 2012, UPMC workers began to talk about forming their union. I wanted in. In Pittsburgh, everyone knows the union turned dangerous, low-paying steel jobs into middle-class jobs. If workers came together, I knew that I could make a better future for my wife Cindy and daughter Hannah, my co-workers too. But instead of respecting our rights to organize our hospital better, UPMC launched a fierce anti-union campaign. We were faced with threats, intimidation. One of the first scare tactics was holding a mandatory staff meeting to attack the union. Management's harassment of me got worse when I wore a sticker saying, "I'm with Ron," to support Ron Oakes, who was illegally fired from UPMC for union organizing. After that, I became a prime target for the management anti-union campaign. Management followed me around and threw out my pro-union literature. I was ostracized to the point where many co-workers were scared to talk to me about the union. Then things came to a head after years of having positive work evaluations. I was placed on a performance improvement plan. Soon after, in 2013, I was illegally fired along with others who wanted the union. We fought the terminations in 2014. A judge from the National Labor Relations Board said UPMC has violated our rights and ordered them to put us back to work. In 2018, the Nlrb told them again, but UPMC is still appealing my case. Sadly, my story is not unique. Working people are supposed to have union rights, but we have to risk everything to exercise them. We need new laws like the PRO Act to hold companies accountable to make it easier for people to join the unions. We must stop them from using scare tactics like captive audience meetings. We need real penalties so companies will think twice about illegally firing people like Ron and myself. We need to force companies to make things right quickly when they break the law. The federal government twice found UPMC wrongly fired me, but 6 years later, I still haven't returned to work or seen a penny of back pay. And everything I earned since I was fired is deducted from what UPMC owes me. By trying to provide for my family at another job, I'm working off UPMC's debt. That's not right. I urge the member of this committee to support the PRO Act and help ensure what happened to me doesn't happen to anybody again. Thank you.
Thank you, Mr. Stiles. We will now recognize Ms. Samara.
Thank you.
Welcome.
Chairperson Wilson, Ranking Member Wahlberg, and subcommittee members, thank you for the invitation to be here. I'm a partner in the law firm Morgan, Lewis & Bacchius, but I had the privilege of serving as chairman of the National Labor Relations Board and board member or acting chairman from 2013 to December 2017. I might add, I served on the NLRB with my friend Mark Pierce, who is seated here to my left. I'm also a senior fellow in the Wharton Center for Human Resources at the University of Pennsylvania's Wharton School. Everyone in Congress wants to do good when considering changes in our federal labor laws. Based on 4 reasons, I think the changes proposed in H.R. 2474, though intended for good, would do significant harm. First, this legislation disregards the remarkable work done by the NLRB and especially its dedicated career professionals and staff members throughout the country. Parties can pursue an NLRB charge from start to finish without a lawyer. Also, nearly 20,000 unfair labor practice charges are filed annually, and roughly 90% are completely resolved within 3 or 4 months, and employees get near immediate relief in those cases. And in the 5 or 6% of cases that are not resolved at this early stage, the overwhelming majority of board decisions are unanimous. Here's my second point. The National Labor Relations Act carefully balances the competing interests of employees, employers, unions, and the public. H.R. 2474 would dramatically change this balance. For example, the bill would permit union strikes and boycotts targeting neutral parties, basically everybody who does business with the struck employer. These secondary boycotts have been unlawful for more than 70 years. Another example, any struck employer would be prohibited from continuing operations using permanent replacements. Employers, but not unions, would be barred from being parties in NLRB election cases. In many cases, the bill would eliminate the employee right to vote in NLRB elections, substituting mandatory union recognition without an election. In many first contract negotiations, the bill would eliminate the employee right to vote on contract ratification, substituting arbitrator-imposed terms for a 2-year period or more. The bill provides for 2-track NLRB and court litigation over the same issues with expanded damages. The bill would override state laws adopted in more than half the country that prevent employees from being forced to make mandatory union agency fee payments, and the bill would even redefine the terms employer and employee. My third reason for opposing this bill involves the role played by economic weapons. Now, the NLRA was adopted during the Great Depression. It centers around a bargaining model where leverage is based on each side's potential infliction of economic injury on the other party. In a global economy, this puts unions and employers in a relay race, and in the United States, unions have an incentive to use the baton to injure the employer instead of running the race against global competitors. H.R. 2474 increases the intensity of the weapons while expanding the role played by conflict and economic injury. I think this moves U.S. labor policy in the wrong direction, especially when it comes to trade, jobs, and our place in the world economy. Finally, as everyone knows, recent years have spawned dramatic advances in robotics, self-driving vehicles, artificial intelligence, and automation. Simply stated, this is the worst time in U.S. history and probably the worst time in human history to adopt a national labor policy that increases employment-related conflict, costs, and disruptions which companies can and will avoid by using more fully automated systems. This bill, if enacted, will inevitably cause more investment in technology and less investment in people. I will conclude with this. Congress produced a remarkable achievement in the National Labor Relations Act, which the Supreme Court said is not intended to serve any party's individual interest, but to foster in a neutral manner a system in which conflict between these interests may be resolved. H.R. 2474 departs from this neutrality, and I think it would disadvantage employees, employers, unions, and the public interest. Thank you again, and I look forward to the subcommittee's questions.
Thank you. Thank you very much. We will now recognize Mr. Pierce. Welcome.
Thank you, Chairperson Wilson. Thank you, Ranking Member Wahlberg. I really appreciate the opportunity to speak here today. This is a special privilege for me because I spent half of my 40-year career working with the National Labor Relations Board first as a lawyer, then ultimately as a board member and as a chairman. The National Labor Relations Board is the agency charged with enforcing the foremost labor law in the country, the National Labor Relations Act. It has, however, been hampered in effectively enforcing the act because of its remedies failing to deter unlawful conduct. That is why the statutory change is needed, to update the law to reflect today's workplace. Compare Congress with an auto plant charged with producing legislation to protect working people in this country. The NLRA would be described as a heavy-duty vehicle with major design flaws, an underpowered engine, and only 3 wheels. I'd like to highlight 4 main shortcomings of the law as it exists today: inadequate remedies for violations, procedural obstacles to relief, insufficient protections during the bargaining process, unfair remedies in cases involving undocumented workers. With regard to inadequate remedies, Section 10C of the National Labor Relations Act limits remedies to a cease and desist order in the event of an unlawful firing, reinstatement with back pay, along with a required notice posting. That has been, in effect, a slap on the wrist. By contrast, other worker protection statutes, like Title VII of the Civil Rights Act and the Fair Labor Standards Act, provide compensatory damages, liquidated and sometimes punitive damages. These people have been harmed. They've been damaged. They don't have to have a requirement that requires them, as this worker just testified, to pay back the debts of the wrongdoer in order to be entitled to compensation. Limitations in the current statutory scheme make it economically rational for employers to violate the act. An example being a case that is cited by both me and my colleague, Mr. Miscamara, Pacific Beach Hotel, which is detailed in my written statement. That's a case where, for the span of 10 years, the employer blatantly violated the National Labor Relations Act. And each time when the board went back, they'd have to go into court to enforce the orders. Each time, the parties had to pony up big legal expenses in order to get that done. Each time, employees were told that they would get recompense and that the unilateral changes that were being created will be rectified, and each time the employer violated it for 10 years. The question becomes, what does an employee think of an act when for 10 years they're being abused by an employer and there is nothing in the act to stop it from happening? Procedural obstacles to relief have been significant. When workers file charges with the NLRB, they're often left to work for a significant period of time, and in many instances, as the chairperson eloquently said, justice delayed is justice denied. By the time a case works its way through the NLRB process, its litigation in federal courts several years may have lapsed. For this reason, only 1/3 of those people entitled to reinstatement accept reinstatement. The PRO Act would help address the problems of delay by authorizing the board to seek injunctions in federal district court. Strengthening the protection of during the bargaining process is something that is also going to be needed, and that's detailed also in my report with mediation and arbitration of contract issues, an essential piece of a bargaining process designed to facilitate collective bargaining. I could say a lot more, but I'm out of time. Thank you very much.
Under Committee Rule 8A, we will now question witnesses under the 5-minute rule. Thank you so much for your testimony, riveting testimony, and we appreciate it. I will now yield myself 5 minutes. Mr. Trumka, the right to join a union is an internationally recognized human right and protected by federal labor laws, but in the United States, it is frequently violated in practice. Why do workers need unions? How can civil monetary penalties and damages for severe economic harm deter employers from retaliating against workers engaged in union organizing with near impunity? It's a two-pronged question.
Madam Chairman, workers need unions because the power imbalance between employers and individuals is vast. An employer is not required to talk to an individual employee or even a group of employees to ask them what they want. Only whenever they come together as a union in concerted activity do they have the power and the ability to talk to union for a union. And what happens is evident. They make more money. They're a benefit of roughly 13% more. Latino women make $11,000 more for being in a union. African Americans make $9,000 a year more for being in a union. Women in general make $9,000 more for being in a union. Only by being in a union can they talk collectively and actually bargain for a fairer deal. We've seen what's happened since the union density has fallen in this country. Wages have stagnated and gone backwards. There was recently a study that said that the lack of union density has also hurt non-union workers to the tune of $2,700 a year. If unions had been the same density as they were in the 90s and 80s, non-union workers would be making $2,700 a year more. So it is to balance the scale, to balance the power of employers and employees. Workers have to come together and speak with one voice, and then they can come to the table and negotiate as equals, not as supplicants. That's why it's so important. It's for dignity, it's for respect, and it's for the ability to raise their standard of living and get a fair share of what they produce.
Thank you. I understand, Mr. Strauss, that UPMC fired you for union organizing in 2013. 5 years later, the National Labor Relations Board ordered that they reinstate you with back pay, and they have not done so.
No, ma'am.
Why were you fighting so hard, and why are you still fighting?
Well, I'm fighting so hard, not only for myself and my family, but for the region, the Pittsburgh region. What they're doing at UPMC is wrong, and they need to be held accountable for their actions.
What needs to change in the laws to safeguard your rights and your fellow workers' rights?
Well, we need the PRO Act to take effect because right now the laws as they are today have no teeth. The UPMC and the like are able to get away with whatever they want, and there's no repercussion for them.
Thank you. Mr. Pierce, your career embodies the best in public service. In your testimony, you described how, despite your best efforts, the NLRA fails to deter or fully remedy violations. What are some of the obstacles workers face when they seek to vindicate their rights, and how would the PRO Act address those obstacles?
Well, one major obstacle is that an employee does not even know what their rights are because they are not permitted the opportunity to see notices, just like with the Department of Labor and with OSHA. They can have notices on the wall. The National Labor Relations Act is not placed on the wall. Efforts have been made for us to be able to do that, and it was struck down by the courts by the opposition of forces that were led by my esteemed colleagues here while he was in private practice. But Then there is the protracted nature of the process. The investigations take about 30 days. The trial takes almost a year to culminate, and then afterwards it is appealed to the board, where the board can take a significant amount of time before a decision gets issued. That decision is not self-enforcing, so that the parties can appeal that to the courts and have it tied up for a significant period of time. Meanwhile, people are losing homes, people are getting divorced, people are not able to meet their rent or pay for their children's education. People lose hope.
So much for your testimony. I now recognize the distinguished Ranking Member Wahlberg for his round of questions.
Thank you, Madam Chairwoman, and thanks to the panel for being here. Mr. Miscamara, HR 2474 requires business owners to turn over reams of personal information about workers to unions, including home addresses, home phone numbers, cell phone numbers, personal emails, and much more. If this legislation is enacted, would workers have any say in whether their personal information is shared with the union? And second, what risks might this scheme create for workers?
Representative Wahlberg, thanks for that question. When the NLRB was engaged in rulemaking, which led up to the adoption of a new election rule in 2014, significant concerns were expressed about the lack of consent or any opt-out procedures or any safeguards associated with what would be the new requirement that employers would provide personal information to unions in connection with NLRB-conducted elections. And the personal information includes personal telephone numbers, work telephone numbers, cell phone numbers when they're available, work email addresses, and when they're available, home email account addresses as well. There were concerns that were expressed. We had a 2-day hearing in connection with that rule, and the board ultimately adopted a requirement that these disclosures take place without any safeguards associated with this personal information, and also without any provisions for consent or opt-in or opt-out. HR 2474 codifies exactly the same disclosure requirements, and there really are not safeguards in the bill, nor are there in the regulation that was adopted by the board, and it's currently still in effect.
Far different than getting approval, voluntary status from workers saying, yeah, sure, this is information I want to know about, so here's the information that you need to get a hold of me. Mr. Miscamara, union corruption remains an unfortunate problem. It's not in every case, but as seen recently in my home state of Michigan with the UAW, where union leaders spent hard-earned worker dues on excesses like $1,100 pairs of shoes, two $37,000 gold pens. Fortunately, Michigan is an employee-free choice state, so workers cannot be forced to fund such extravagant and likely illegal spending against their will. However, HR 2474 prohibits states from enacting right-to-work protections. Would banning right-to-work laws make union leaders like those at the UAW more or less accountable to workers?
Well, Representative Wahlberg, the bill would override the state right-to-work laws passed in 27 states that protect employees from being forced to make mandatory union agency fee payments. And one of the points that I made in my oral testimony as well as my written testimony is that the bill really does not continue the balance between competing interests among employers and employees and unions and the public. And with respect to obligations and requirements under the law, the bill would impose significantly greater requirements on employers, and there are no additional requirements on unions.
Okay. Mr. Miscamara, according to polling from Opinion Research Corporation, 81% of union households and 81% of Democrats support the right to a secret ballot in union elections. HR 2474 allows unions to automatically be approved under certain circumstances, even after they lose a secret ballot vote, What risks does it create for workers to allow unions to be certified without winning a secret ballot?
Well, the challenge in those cases is to the extent that employees have not had the opportunity to vote in a secret ballot election, it's not clear what the employee sentiments are with respect to union representation. And the preferred method for decades under the National Labor Relations Act has been for union sentiments to be tested in the context of an NLRB-conducted secret ballot election, which the board conducts in a very efficient and very effective manner that instills confidence in all the parties. To the extent that, as the bill would require, to the extent that in particular cases, bargaining orders would require union recognition and negotiations without any secret ballot election. In those instances, once the union is in, there are significant challenges associated with the ability of employees to ever vote on the possibility of decertifying the union or continuing union representation. Of course, if you don't have an election, you don't know how the election is going to turn out. So once a union is in, there are certain bar rules. The existence of a 3-year contract, for example, would prevent employees from even having an NLRB election until the last 90 days prior to the expiration of that contract. So bypassing a secret ballot election, at least with respect to current law in the board's practice for 83 years, is a very significant issue, and one never knows what the employee sentiments would be expressed if they had the opportunity merely to express those sentiments in a board-conducted election.
I thank the gentleman.
Thank you so much, Mr. Wahlberg. We will now go to the members' questions. Mr. Norcross, New Jersey.
Thank you, Madam Chairwoman, and appreciate you putting together this hearing, and certainly to my colleagues on the other side of the aisle who we have many similar views, but on this one, I think we're going to diverge just a little bit. Isn't it ironic that we're hearing about corruption and we're being challenged by members of Congress talking about this? Or is it more ironic that we're talking about preserving elections when Russians just hacked ours and we're trying to shut that down? Can we get back to the point here that if we look at the density of unions over the course of the last 25 years, and it's declined, the middle class is doing worse, and the fact of the matter, we're having more challenges at the Nlrb. You know, for 37 years, I was an electrician. I was a union representative. I filed probably more elections at the Nlrb than this entire group combined. I understand firsthand how it works on both ends. And I'll start out by saying, not every employer is a bad employer. We have some very good employers that we work with. But when we have the bad ones, they can abuse this system to the nth degree, literally crushing people like you. So when we have a conversation, I want to remind, we have 213 attorneys in Congress, and there's only one electrician. What's my point is, I understand this. I've lived it from both sides. So, Mr. Trumka, thank you for coming in. And you understand, you've heard, you've lived coming out of the mines, how tough it is sometimes. When we look at, finally, as the process goes, you file for election, and let's just assume that the union wins it, then you have to sustain that recognition. And let's say you make it through that second step, and then you try to bargain for your first contract. What happens then typically when there's an adversarial relationship? Is this something that they can force their way and say, let's get a contract, let's go to arbitration and figure this out? Or what typically happens?
Turn on your
Let me
mic.
start with the general statement and work down to what you said. The law, as currently written, gives the employer to decide whether or not workers will have a union. It was never intended that way. Since 1935, the law has allowed and accepted the fact that when a worker and an employer don't disagree, you can have recognition without an election. They do it most of the time in the country. So that's been, since 1935, been the law Only recently has it been questioned. Now, one of the colleagues here wanted to make this seem like this was almost like a governmental election. Well, when you will get elected, you're getting elected to govern. When a union gets elected, it's to represent the workers there. It's like their lawyer. That's all that they're getting at that point. I might add that whenever a majority of people or a minority of people don't vote for you, they're still governed by what you do afterwards forever. In this election with 14B, they get a chance to say, we vote no. We also won't get in, but we want all the benefits that the union has to bring. And we don't have to pay a cent for it. That's what you're sanctioning here. That's what comes out. What happens is normally an employer will surface bargain. They will not bargain with you. They won't give you proposals. It doesn't go back and forth. The first thing will happen is you ask for information, and it will take them several months to get you the information, and then it's not all there. So you ask for it again, and if they don't give it to you, then you go to the board, and you go through a bunch of charges that takes 3 or 4 years. Finally, if you get the information, they sit down. They're not required to agree. All they do is mouth empty words at you. And you can tell pretty quickly if they're trying to get to an agreement or whether they're trying to get to impasse so that they can declare things and go on their merry way.
So what typically happens to the person of the workers who've organized this? Are they targeted? What usually happens to the town?
Absolutely. They always get targeted. They always get targeted, they get fired, and as you heard from my friend next to me, it will take months, years for them to get back. And when they do get back, all the money that was spent defending them is tax deductible. Any money that the worker gets or earns in that interim period is deducted from what the employer pays. It virtually costs them nothing. In the case of Como Tire, we had a guy that was fired. He got fired at a non-union shop, and he went to a union shop and actually had better wages. So when he gets put back in 3 years, they'll owe nothing.
Rich, thank you. We're out of time, but I want to thank you for your testimony.
Thank you.
So much. Thank you so much. Dr. Fox? Distinguished Dr. Fox.
Thank you, Madam Chairman. Mr. and Ms. Kamara, last time Democrats held the majority in the House, they voted to deny workers the right to a secret ballot for union elections. This is a right guaranteed to all Americans when they vote for representation in Congress, and the same right guaranteed to congressional Democrats when they vote for their own caucus leadership. Under H.R. 2472, could some unions be automatically certified even though they lose in a secret ballot vote, and why might union bosses prefer this scheme?
Thank you for the question, Dr. Fox. The H.R. 2474 specifically provides if a union loses an election and if there are unfair labor practice charges that are filed, if the employer does not sustain the burden of proving that any unfair labor practice charges would not have altered the outcome of the election, the union is then automatically recognized as the exclusive bargaining representative without conducting another election. And as I explained previously, that prevents employees from being able to express their sentiments in the confines of the voting booth, which the board has always said is the preferred course for testing employee sentiments regarding union representation.
Thank you. Mr. and Ms. Kamara, despite Democrat claims that the decline of unions has harmed workers, Americans are inarguably better off today than they were decades ago when the union participation was higher. And by the way, we have the figures to prove that, despite what others may say here today. A significant provision in H.R. 2474 repeals the ban on secondary boycotts, subjecting even more employers, workers, and customers to union harassment. In your view, does this provision, not to mention the bill overall, threaten economic growth, and what impacts would secondary boycotts have on business owners, workers, and the overall health of the U.S. economy?
Dr. Fox, the term secondary boycotts is an important one when it comes to labor law. And what a secondary boycott means is if a union has a dispute with you, under current law, the union can move forward and use picketing and other means, other economic weapons against you, but the union can't spread that dispute to everybody in our complicated economy merely because they do business with you. In the United States, we had that state of affairs for 12 years. The act was passed in 1935, and then there were amendments that were made in 1947 that, among other things, barred secondary boycotts because they were having too debilitating an effect on the U.S. economy. The next amendments to the act occurred in 1959, and Congress strengthened the prohibitions against secondary boycotts because there were loopholes during the original restrictions that still permitted labor disputes to have widespread debilitating effects throughout the economy. What H.R. 2474 does is repeal in their entirety the provisions that bar secondary boycotts. So we would have, under this bill, not only the type of conflict and dissension that, as I indicated, is part and parcel of our collective bargaining model under the statute, but we would return to a state of affairs that has not existed in this country for more than 70 years, which would be a very, very significant change in the law.
Thank you, Mr. Miscamara. In the event of a collective bargaining impasse, H.R. 2474 requires employers and unions to enter arbitration, allowing unelected bureaucrats to write a binding union contract. The bill states that the contract, quote, shall be based on the wages and benefits other employers in the same business provide their employees, end quote. Does that mean that under this standard, a mom and pop retail small business would have to accept the same union contract terms as a mega corporation like Walmart or Amazon? What effect would this mandate have on small businesses and their employees?
Well, Dr. Fox, there are two potential effects. One is we don't know what an arbitrator would do in that circumstance where the arbitrator inherits, these are initial contract negotiations, where an arbitrator inherits a small business, a union, and various competing demands that may be very, very far apart. And there's a risk, since we're talking here about contract terms that are imposed and not agreed upon, there's no certainty regarding what the employer could confront, and it's possible that imposed terms would actually be not only injurious to the employer, but injurious to the employer, the employees, the union itself, even though the union was seeking those terms. The one other point I'll make is that current law has been very clear that the NLRB regulates the process of collective bargaining, but the NLRB does not have the authority to impose substantive contract terms on parties. That has worked very well for the Act's 83 history. This law, for the first time in the Act's history, would change that.
Thank you. Let's wrap it up.
Thank you, Mr. Miscamara, and thank you, Madam Chairman. I'd like to enter into the record an article called Big Labor's Big Shrink, which was in the Wall Street Journal on April 30th. Thank you.
Now, Mr. Morrell.
Thank you, Madam Chair, for holding this hearing, which is so important, and to all of our witnesses who are testifying today, in particular, Mr. Trumka, thank you for your lifetime of efforts on behalf of America's working families. You know, over the past 4 decades, there's been a concerted effort to diminish the right of workers to organize and collectively bargain, and we've seen the impact of that in my district in upstate New York and throughout our country. These concerted efforts have had a serious impact on union density in Rochester, where I represent, and surrounding communities, resulting in suppressed wages for union and non-union workers. Something that's not often talked about is the impact on non-union workers because of the impact on union organizing. As the proud son of a pipe fitter and a member of Plumbers and Steam Fitters Local 13 United Association, I'm glad to have the opportunity to focus on what can and should be done to deter unfair labor practices. And I want to start, if I might, Mr. Strauss, if I can ask you, federal law states That's the policy of the United States government, quote, to protect your freedom of association and promote collective bargaining, end quote. The National Labor Relations Board decided in 2018 that you were unlawfully terminated, but your employer has not yet given you a cent of back pay, as I understand.
That is true.
From your testimony. I gather that's because the NLRB is weaker than other federal agencies and that it cannot enforce its own orders. With that in mind, do you feel the law as stated is living up to its stated purpose?
No, it is not. We need something like the PRO Act to give the law some teeth, because it's been 6 years, and I haven't got penny one or reinstated.
Thank you. Obviously, a law failing to meet its stated goal needs to be changed and updated, the purpose of our conversation here. I wanted to just, if I could, Mr. Pierce, because of that lack of the ability for the NLRB to have sanctions or be able to implement sanctions, how do employers abuse that deficiency in the law? Could you just describe that a little bit?
Well, employers are able to, if they want to snuff out a union's organizing drive, the employer can take full advantage of violating the law with minimum repercussions. You terminate an individual like Ron Oakes and kill the organizing drive, you could possibly put the back pay owed to that individual in a low-interest savings account, and by the time there's a determination that you have to pay, and you subtract the interim earnings from that, you have made money on your wrongdoing.
Obviously, something the law is not intended to provide an opportunity for that.
Not at all.
One just follow-up. In Mr. Missamara's testimony, and this is from Mr. Pierce, I'm just curious, he cites 2014 case Pacific Beach Hotel as an example of the NLRB having sufficient teeth to defer unfair labor practice. I noticed that you cite the same case in your testimony, sort of unusual that you both point to the same thing. Were the remedies that Mr. Missamara listed actually significant? Were they enough to deter the employer from violating the NLRA over a period of years? Because deterrence is obviously a big part of what we hope to do with sanctions.
We were talking about a recidivist that engaged in bad doings over the span of 10 years. And repeated violations of the act were brought forth and pursued in court. We ultimately, as a unanimous body, concluded that these egregious violations needed to be remedied. We went through every possible effort to fit the crime, the remedy with the crime, within the limitations of the statute. And a lot of that was upheld by the court, even though it was dissented to by some of our colleagues. The one remedy that was significant is the court costs of having to go to court each time in order to rectify these circumstances. And we ordered court costs to the general counsel and to the charging parties because of the abuse of the process that was being subjected to. Well, the DC Circuit, while they upheld our other efforts, struck that down because there was no statutory authority for us to impose those things. So otherwise, resources that were utilized to try to enforce this were denied this agency so it could not effectively investigate cases and apply its resources in order to protect the working people.
Very good. Well, thank you, sir. Thank you, Madam Chair.
Thank you. The renowned Dr. Rowe.
Thank you, Madam Chairman. I appreciate that. First of all, welcome back, Mr. Miscimara and Chairman Pierce, to the committee. It's good to see both of you again.
Thank you.
I grew up in a union household, as Mr. Wahlberg did. My dad worked almost 40 years, United Rubber Workers Union. I think it's steel workers now. 45 years ago, I put on a uniform, left this country, and served 11 miles south of the DMZ in Korea to ensure that you had the basic rights given to you by the Constitution of this country, which is a secret ballot. I say this jokingly, but my wife claims she votes for me. I don't know for sure that she does because it's a secret ballot. And that's the way it should be. And I bet Mr. Trumpka was also elected by the secret ballot. I know everybody on this dais was. I think that's one of the most fundamental basic rights we have as an American citizen is a secret ballot. And we should protect that above almost anything. It's what helps guarantee our democracy. I can say I appreciate what the unions do in many cases in apprenticeships. I worked with you on that, and certainly we've had legislation here. In Tennessee, in my state, we have 3.2% unemployment, and the union penetration there is about 5.5%, I think. And I don't believe the problem is a decline in not too few unions. I think the problem in my state is too few skilled workers. We're looking to find workers. Everywhere you look, there's a help wanted sign in the state of Tennessee. So a second thing I want to bring up is the personal information. Look, I think that's yours, and you should decide as an individual. You have the freedom to do that. If you want to share that information, you should be able to do that, but it shouldn't be required of you. And lastly, before I ask some questions, I want to enter, Madam Chairman, into the record a letter that 82 House Democrats, including Chairman Scott and 11 other members of this committee, wrote to Ambassador Lighthouser. Some of the members serve on the Help Subcommittee. In it, they say this, that they express concerns in the USMCA agreement that the ability of a Mexican worker to exercise a free, secret, and personal vote on a collective bargaining agreement. So why are my colleagues advocating the basic right for a Mexican worker, but denying that right for an American worker? And right here it is, and I'd like to submit that for the record. And I would assume, given that this members would vote against their own bill, because I do believe that the PRO Act is a solution looking for a problem, not the other way around. Ms. Miscimara, I want to ask you a couple of questions. And 2474 requires employers to turn over reams of personal information to the union about every worker, such as their home address, phone number, cell phone, personal email, and other things. In your experience, how have you seen this information used?
Well, you know, I can't address, Dr. Rowe, how the information is used, but as I indicated before, there were not, the bill does not provide for safeguards regarding the use of this information, and that was a source of significant concern during the public hearing that was held when the Nlrb was considering the adoption of the 2014 election rule. One thing, though, that I would like to address is my colleague, Mr. Pierce, made reference to the Pacific Beach case, and that was a case, unquestionably, it dealt with a recalcitrant employer, and the board imposed extraordinary remedies on that employer. But as I indicated previously, the board's experience shows that in 95% of the cases that are filed, there are not recalcitrant employers. We're talking about cases that get resolved 95% of the time within the first 4 to 6 months. And so these recalcitrant employer examples are the tail of a dog. And what this legislation, I think, effectively does is it takes a problem with the tail and then dismembers the dog. You know, I think that operates to the detriment of not only employees and employers, but also unions, too.
I think one of the problems with declining union membership has been my dad was into manufacturing. He lost his job to Mexico many, many years ago. And I think you're beginning to see those come back, and that's a very good thing under the current policies of this administration. My colleagues claim that the employers must hand over workers' personal information, otherwise unions have insufficient access to employees. Is that true?
Well, I don't think so, Dr. Rowe. And, you know, we had a case that dealt with union organizing efforts or employee organizing efforts. It's called Purple Communications. And the question there was whether there were adequate means by which employees could organize or communicate with one another. And in connection with that case, one of the points that I made in a separate opinion was that We've seen entire national uprisings about that have resulted from the use of social media. And so the notion that there has to be specific employer-provided information for effective organizing to occur, I don't believe has support.
Thank you, Madam Chairman. I yield back.
Thank you. Ms. Wow?
Thank you, Madam Chairwoman. I am proud to be a co-sponsor of the PRO Act, and I thank you, Madam Chairwoman, for holding this subcommittee hearing. I am deeply troubled by the different standards for the actions of employers and the actions of employees or labor. I believe it has a chilling effect on workers' right and ability to organize. Mr. Trumka, I'd like to address the mandatory captive audience meetings that are held. It's my understanding, and correct me if I'm wrong, that under current law, an employer can hold a mandatory captive audience meeting to dissuade employees from unionizing so long as it is not held 24 hours prior to an election and as so long as the meeting does not overtly threaten reprisal, correct?
That's correct.
On the other hand, if an employee leaves the meeting without permission, that employee is subject to penalty up to the point of termination. Is that fair to say?
Not only that, if an employee speaks up in a meeting and tries to rebut an untruthful statement that's made, they can be fired.
Thank you. And yet, it's, as I understand it, not permitted for a union or workers to campaign during work time, correct?
That's correct.
And they have to campaign during breaks or off-site or after working hours. Is that true?
Correct.
And yet there is no limit under the law to the number of mandatory captive audience meetings that an employer can hold. Is that true?
That's correct. In fact, in Como Tires, they had 2-hour sweat sessions every day for 25 consecutive days, stopped the day before the election.
And these are held throughout the workday, on work time, on the work site, true?
On work site, and they're mandatory. You don't have the choice to go or not to go.
It seems to me that that creates a rigged system, one that is almost destined to ensure that organized labor fails at its efforts. Is that
Just the
fair
fact
statement?
that they can make you go to a meeting demonstrates to workers how much power they have. And then the fact that you can't speak demonstrates the power again. The message is, I have the power, you don't. I will use it, you can't.
And we've heard from Mr. Staus, who lost his job, and is it your belief that workers who want to organize would be subject to the same kind of fear of losing their jobs? Mr. Trumka.
Would you repeat that, ma'am?
Yeah, my question is whether these policies that we've just talked about lead employees potentially to believe that they will be terminated if they try to organize.
Absolutely. They're threatened with it, and not only that, they actually fire people. They fire people like my friend here, and they put the head up on the wall, and they say to people, if you exercise your rights, the same thing will happen to you. And yes, maybe 4, 5, 6 years down the road, I may have to pay you back pay. I get to deduct everything in the process of all the expenses, and I get to deduct from any back pay I may owe you, any earnings you may have in the interim. So it becomes virtually a cost of doing business, and these things occur in more and more and more frequency these days. Captive audience meetings are held in over 90% of organizing drives right now, and the number is growing. Before long, it'll be 100%.
Not only is it a cost of doing business, but in fact, it's often economically more beneficial to the employer to do exactly that. Isn't that true?
Absolutely.
I have a question for any of you, but let me address it to Mr. Pierce. Under federal law, workplace notices have to be conspicuously posted, advising employees of their rights under Title VII, the ADEA, FMLA, and OSHA. Why is it that there are no mandatory workplace notices advising employees of their rights under the NLRA?
I'm sorry, because it's not specifically set forth in the statute. As I said in my opening statement, this is a car with 3 wheels, with an underpowered engine. This is an act that is not self-enforcing. We have to wait for complaints from individuals if it's subjected to unfair labor practices. Clearly, we're not going to get those complaints if those individuals don't know their rights.
Thank you, Mr. Pierce. Madam Chairwoman, I ask recognition and unanimous consent to introduce into the record a letter dated May 8, 2019 from the International Brotherhood of Teamsters.
So ordered.
Thank you. I yield back.
Thank you. Mr. Allen?
Yes, and thank you very much. You know, Mr. Strauss, it's sad that you or anyone was mistreated in the workforce. In this new economy, the best economy in the world, and I get out among the businesses because I come from the business community, and the people I talk to are growing wages and benefits to really keep their key people. In fact, in this, with the best economy in the world, and you know, when I talk to folks, particularly about federal government interference with things, we don't need more laws to deal with, you know, labor shortages. We need more skilled workers. And my experience is initially as a union contractor back in the early 70s, the reason that the biggest problem we had was a shortage of skilled workers. And so we had no choice but as companies to recruit and train workers to assist us to get the work completed, and so did our subcontractors. And as a result, the unions, you know, most companies now are open shop or dual shop or whatever to allow for that flexibility. But bottom line is, in this new economy, companies are partnering with workers, particularly as it relates to 401ks and ESOPs, which for whatever reason, and Mr. Mascara, you might can shed some light on this, be my first question, is I understand that the unions fight or ESOPs and 401k or anything that rewards employees beyond their abilities in a company, and these companies are, like I said, fighting to keep their workers, and so they're doing this, and like I said, a lot of them are going to ESOPs, and they're working out very well for their employees. Do you have any comment about, you know, how the two work together?
Representative Allen, thank you very much for the question. The one thing I'll say is probably one of the most important and the most challenging for all sides question that comes up in collective bargaining, and certainly this has been true for the past 20 years, involves methods of compensation and the various arrangements that are much more complicated than they are today than they were 10, 20, or 30 years ago. And so with respect to various types of, especially retirement plans and other types of fringe benefits, it's from soup to nuts, it's all over the map, and I think that those present challenges for everybody. The one other thing, if I may, Representative Wild raised a question, why is there no notice requirement in the National Labor Relations Act? In point of fact, the original version of the Wagner Act legislation in 1934 had a proposed notice requirement, and it had a separate unfair labor practice that targeted employers that failed to comply with the notice requirement. During the legislative debates, it was discussed. Senator Wagner himself expressed opposition for that requirement. It was removed from the bill.
Well, certainly my suggestions to our friends with the unions is to, if they can recruit skilled workers in this economy, you're going to find work. I can assure you of that. Let me ask you, Georgia is the 6th best state in the country to do business, or the best state to do business with 6 years in a row. We're a right-to-work state. We have, I was at a union project, a nuclear power plant, met all the workers, going well, and we have your companies that are ESOP owned, and like I said, it's what the people want, the right to choose. As far as this legislation, H.R. 2474, how does it deal with right-to-work states? And to give us the flexibility to do what we do and to be the best state to locate business that produce jobs, by the way.
Yeah, well, I mean, what the bill does, the principal effect on right-to-work states that the legislation has is to eliminate the protection that exists in more than half of the country for employees that object to paying mandatory union agency fee payments. And this legislation would override that employee protection.
For example, if I choose to do a job in Washington, D.C., I have no choice. I have to work union. So you're telling me this law is going to affect us like this in Georgia as well?
Well, to the extent that employees end up being represented by a union in Georgia, this law would prevent the Georgia right-to-work law from being given effect, and those employees that have union representation could be required to make mandatory union agency fee payments, notwithstanding provisions in Georgia law to the contrary.
Thank you, sir, and I yield back.
Thank you very much. Courtney? Okay. Mr. Courtney?
Thank you, Madam Chairwoman, and thank you to all the witnesses for being here today. Just wanted to follow up actually on the Chairwoman's opening comments about the value of unions in terms of the standard of living of workers. Up in New England, we actually witnessed the value of collective bargaining when 31,000 workers who are organized with the United Food and Commercial Workers Union and employed by Stop and Shop, a grocery chain owned by Ahold Delhaize, a Danish company, successfully exercised their rights to strike over proposed cuts to their pay and benefits. It was an 11-day strike, and the company obviously calculated that they could outlast the union. What was at stake was almost existential for the middle-class way of life for the people who work there.
Thanks.
The employer proposed increasing health plan deductibles from $300 a year to $5,000 a year. They had proposed more than doubling health insurance premiums. They had proposed removing spousal coverage for health insurance. They proposed eliminating time and a half on Sundays, and they also proposed slashing pension contributions for full-time employees by half. What the company miscalculated was that, in fact, the public would support the picket lines that stood up in those grocery stores, again, in all the New England states. And after 11 days, the strike ended, and the UFCW was successful in restoring all of those out-of-pocket hits that workers would have taken and were not even close to being offset by any sort of modest wage increases which were proposed. So again, from the standpoint of the people who stock the shelves and work the cashier lines, who I met with afterwards, who again felt that they had taken their own economic destiny into their own hands by exercising their right to strike, it obviously paid off big time for them. So I know today, Mr. Missamira's testimony, he has pointed to what he believes the employer's ability to permanently replace economic strikers carefully balances competing interests. The PRO Act obviously would change that to not allow replacement strikers. Just looking at the experience of what just happened up in New England, where, again, 31,000 workers stood up for their way of life and their standard of living. Can you, Mr. Trump, could just talk about how the PRO Act would clarify that employers not being able to retaliate against striking workers and how that would actually facilitate collective bargaining and bring some of these job actions to a swifter conclusion like we just saw?
If in fact you can permanently replace workers, you take away their major leverage. They have no leverage left at that point. And so it encourages employers to facilitate the dispute, escalate the dispute, and to replace the worker. And I'd like to give him a hypothetical. I'd like to offer him a job and say, I'm going to give you a job that pays $1 million a year, and you have 360 days of vacation. And so you come in, you take you work a day or two, and you go, well, I have 360 days of vacation. I'll just take a week. So you take a week, and when you come back, somebody's sitting in your chair. And you go, what's this? And I say, well, I've replaced you. And he goes, but I was on vacation. Yeah, that's correct. But you're now replaced, so you're gone. Does anybody believe that you really have 360 days of vacation? Does anybody believe you have the right to strike when they can replace you for actually exercising that right? Not having that right would force employers to come together with employees to work and actually negotiate a settlement. And so would the arbitration procedure, because no one wants to have something imposed on them. So both sides would have an incentive. First, the employer would have an incentive to give you information quickly, because there's a 90-day limit that you get to do that. Second of all, it would help you come to an agreement, because you don't want somebody else to take the chance that somebody will impose on you an agreement that you don't like. So it would actually encourage, it would level the playing field that is now terribly, terribly, terribly skewed in favor of the employer.
So basically, your experience is that replacement workers basically kind of enable employers to just drag out job actions and delay actually resolutions of these kinds of disputes.
Absolutely.
Thank you. I yield back, Madam Chairwoman.
Thank you, Mr. Courtney. And now, Mr. Banks.
Thank you, Madam Chair. Mr. Miscamara, in your testimony, you say, quote, "The biggest problem with the PRO Act is the expansion of economic weapons and economic injury. Increasing the scope of these economic weapons and making them more destructive will have a destabilizing impact on U.S. employees, employers, the general public, and unions," end quote. I believe you're entirely correct in that statement, especially in this complex global economy that we find ourselves in today. So can you elaborate on why it is so dangerous to weaponize labor relations in the global economy, and how it is especially reckless to do so when working Americans are benefiting more than they have in decades in this substantially strong economy?
Thank you very much for the question, Representative Banks. There are many instances, and in my career, I say in my written testimony that I'm a supporter and proponent of collective bargaining. It's to the credit of so many unions and so many employers that they have maintained and fostered constructive relationships throughout years and often decades of successful collective bargaining, resulting in agreements. But nonetheless, the engine that drives collective bargaining and the engine that has produced every collective bargaining agreement for 83 years under the National Labor Relations Act is either the infliction or the threatened infliction of economic injury. And for a union, that's a strike, work stoppage, protests, or boycotts. For an employer, that's the possibility of a lockout or the possibility of having temporary replacements or permanent replacements. The National Labor Relations Act was passed during the Great Depression. At that time, there was barely a national economy. At the present, we have a global economy, and as I indicated previously, that we've also made massive advances in terms of automation, technological change, artificial intelligence, and self-driving vehicles, for example. So the parties have done well under existing law with respect to a bargaining model that still has as its centerpiece the potential or actual infliction of economic injury. In a global economy, that's very, very different. And I think one of the reasons why many employees have resisted the idea of union representation is it's counterintuitive for many employees to understand that it's in their interest to buy into a model that centers on potential economic injury to the place that employs them.
You mentioned automation again. You also did in your written testimony, and the danger that this poses to existing jobs, especially in production companies. I represent the state of Indiana, home to 544,000 manufacturing jobs, so this is particularly important to me. And while I share your concerns about the effect of automation of jobs, would you agree that technological advancements also make workers more productive and increase available job opportunities if we avoid bad policy choices like the PRO Act that force employers to cut jobs?
I completely agree with that. And as I indicate in my written testimony, the American workplace has proved to be extraordinarily resilient with respect to its ability to adapt to changing conditions. So I think that there are many opportunities associated with technological advancements, but to the extent that we adopt a national labor policy that exacerbates the type of conflict or the costs or the penalties or the efficiency of the workplace itself, I think that will be counterproductive.
Thank you very much. I yield back.
Thank you. And now, our former Secretary of Health and Human Services, Dr. Shalala.
Thank you very much. I sat through this whole hearing in large part because I found Mr. Strauss's testimony so compelling. So, Ms. Amara, you've made it very clear that that you don't favor the bill that we have before us. You've heard his testimony. You were a member of the National Labor Relations Board the first time the Nlrb ordered him to be reinstated by the University of Pittsburgh Medical Center. And then they ordered him again to be reinstated, and they didn't do it. Can you really look him in the eye and say that we don't need to put more teeth into the law to make sure that when the board makes a decision, it is actually enforceable?
Dr. Shalala, thank you very much for that question. In fact, I looked Mr. Strauss in the eye and I told him, I'm from Pittsburgh. I grew up in Pittsburgh. I'm from the same community where he currently lives. And one of the things I'll say is former Chairman Pierce and I worked together for my entire tenure at the NLRB to address one weakness that certainly exists in the law, and I believe Mark and I are in agreement with this. In the 5% of cases that are not addressed and resolved in the first 60 or 90 or 120 days after the filing of a charge, the board needs to do a better job getting cases decided more quickly. And I agree with that. I believe former Chairman Pierce agrees with that. Throughout my tenure at the board, we worked very hard to try to make improvements. It's very challenging. The current board has announced as an objective, both on the board side and the general counsel side, to diminish the amount of time associated with the board's disposition of cases, 20%, taking 20% less time over a 4-year period. Frankly, I still think that's not fast enough. And our current labor laws are not perfect, but I don't believe that HR 2474 is the solution.
Well, but let me push you, because what you did was answer the question about the time it took as opposed to the enforcement. Twice the National Labor Relations Board ordered the University of Pittsburgh Medical Center to reinstate him. It wasn't just the time it took for you to make the decision, it was the fact that it couldn't be enforced, that the National Labor Relations Board couldn't either penalize the University of Pittsburgh Medical Center and make sure he got reinstated. That's my question.
Well, with respect, Dr. Shalala, I don't think that HR 2474 would produce the quicker resolution of these cases. And as there's already been testimony to the effect that in certain types of cases, not only would there be NLRB proceedings, but there could be NLRB proceedings as well as federal court proceedings. And we all know in the panoply of various types of federal laws, the federal courts don't have that great a track record in terms of resolving their pending court cases as well. And of course, a district court case is subject to appeal to the courts of appeals and potentially to the Supreme Court. So again, I think speed is a problem. We tried to address it while I was at the NLRB. The current board's trying to address it, but I don't think speed is resolved in the current legislation that has been proposed.
Yeah, and I don't think speed is the issue. I think enforcement is the issue, and that was my point. Mr. Trumka, if I might ask you a quick question. This year marks the 100th anniversary of the International Labor Organization, the ILO, and it has does the U.S. law comply with the basic standards of the ILO conventions? And how does noncompliance diminish our standing in the world? And how would the PRO Act help promote compliance with international human rights standards?
It does not comply. It does not comply. Our laws don't comply with ILO conventions. There are 8 laid out conventions: freedom of association and effective recognition of the right to collective bargaining. That's conventions 87 and 98. We have not adopted those. The elimination of all forms of forced and compulsory labor. We have adopted 1, that's compulsory labor, but not number 29. Effective abolition of child labor, 2 resolutions, we've only adopted 1. The elimination of discrimination in respect to employment and occupation, we have adopted neither one of those. Currently, there was just a study done by the World Justice Project, it's here. The United States ranks 20th in the world for enforcement of those things. And the way that it affects us the most is because we don't do the things that we ask others to do, we look like hypocrites. We ask them to do something and we haven't done it. We do not protect the right to strike. That's one of the things that the international community specifically addresses and looks at and says the right to strike cannot exist when you can permanently replace anybody who exercises the right to strike. So what it does is it lessens our standing in the world, and it makes it more difficult for us to help people in other parts of the world correct the outrageous labor standards and lack of labor laws that they have.
Thank you. Thank you. Mr. Wright?
Thank you, Madam Chairman. Mr. Misclassifying, I have a lot of union families live in my district. I have a number of building trades unions that operate there. Dallas-Fort Worth International Airport is just outside my district, but I have a lot of families that work there. And the largest non-government employer in my district is General Motors plant, and it's their most profitable plant, and makes their large SUVs. So the unions are important to my district. But Texas is real big on individual freedom and opportunity, and that's why so many people are flocking to Texas for that freedom and opportunities, and why so many businesses are relocating there from other states. And I'll tell you that this is one of the most anti-individual freedom bills I've ever seen. My question to you is, if this were to pass, the upheaval would be enormous, particularly in right-to-work states. And yeah, I can tell you just from my district that unions thrive and do well in right-to-work states. So to do away with that, it just strikes me as incredibly ridiculous. But what can you project, what you think this upheaval would do to us in terms of our national economy, but also, more importantly, in terms of our competitive edge internationally in the global economy?
Thank you for the question, Representative Wright. I think that on many levels, this legislation is ill-advised, particularly as it relates to the competitive position of the United States and in the world economy. Number one, as I indicated, current law, which parties have worked with for many, many, many years, itself represents an incongruity between this model developed in the 1930s, where economic conflict plays such a central role, and the current economy that was barely imaginable in the 1930s when the National Labor Relations Act was first adopted. The second thing that Congress has done over time with our current law has made modifications in order to sculpt or tailor the type of economic conflict that's available under the law. And for example, the ban on secondary boycotts, as I indicated before, was adopted in 1947. It was strengthened in 1959, and it's been the law now for more than 70 years. To the extent that this bill would become law, if a union has a strike or a boycott with any particular company, it would then be permissible for the union to effectuate a strike or engage in picketing or boycotts with every single other entity that does business with that company. That's what a secondary boycott is. That type of widespread turmoil in the economy, especially given the complicated economy that exists today, I think would be debilitating just for the people that are exposed to that conflict in the United States, but it certainly would be even more harmful if you consider the ramifications in the world economy.
Okay. Thank you, sir, and I yield back.
Thank you, Mr. Wright. And now, Mr. Levin.
Thank you, Madam Chairwoman, and I have a couple of slides I'd like to put up there when the staff get a chance to put them up. And the point of these slides is to show how we've been going in the wrong direction on workers' freedom to form unions and how the law is completely failing and has been for decades. I started organizing nursing home workers for SEIU in 1983, so I picked this as a start date. And the number of elections held every year back then was about 4,500. The number of NLRB union elections declined by more than half from the days when I started through the late aughts, which is the latest date we have available. And this is 0.02% of private sector employers had any kind of election. If you look at the next slide, the number of workers who cast ballots declined significantly from 1983. In the early 80s, it was in the low 200,000s. In the late aughts, it was 100,000 plus or minus. In 2009, the number of private sector workers who cast a ballot was 0.009%. I don't know even how to say 900ths or thousands, whatever that is. This is when 62% of people say that they are in favor of unions, and if we had a perfect free market for unions, 30% of workers would be in union. This system is completely failing the workers of the United States. Mr. Miscimara, is that how you pronounce your name?
Miscimara.
Miscimara, thank you so much. Your testimony states that requiring injunctions for temporary reinstatement upsets what the Supreme Court calls, quote, the delicate task of, quote, weighing the interests of employees in concerted activity and the interests of the employer in operating his business in a particular manner. At the end of your term as chairman in 2017, you issued 5 decisions overturning prior precedent, including in high-brand industrial contractors. Is that correct?
I believe that's right.
And so the case, the high-brand case, involved 7 employees who were fired for protected activity. And there was also a question of whether those employers were a single employer or joint employers. And if they were joint employers, then that would have been governed by the Browning-Ferris decision. In your October 18th, 2017 email circulating a draft decision in high-brand, isn't it the case that you told the other members of the NLRB that your draft decision was lifted from your dissent in Browning-Ferris and that members should resist the desire to improve the language in order to keep the focus on overturning Browning-Ferris? Is that correct, yes or no?
In fact,
Is that what the email said? Because I'm going on to another question, so I just need to know whether you said that. I mean, we have the email, so I know the answer.
Well, then I'm asking, why would you ask me the question?
Oh, well, so let me continue.
Respond. What I told my fellow members was that the dissenting opinion in Browning-Ferris Industries was so insightful, I didn't believe it could be improved upon.
That's modest of you. So because a member Emanuel's former law firm represented a party in Browning-Ferris, didn't the Inspector General and the ethics official find that he violated his ethics pledge? Did that occur? I only have 5 minutes, so I need a yes or no answer.
Well, you asked me there's compound.
I asked you if it occurred or not.
The Inspector General issued a report that I believe is publicly available with redactions, and I've never seen, and I don't believe it's been released, what the designated ethics officer concluded in the case.
Well, it doesn't really sound delicate or even-handed to me, sir. Mr. Trumka, none of the NLRB members in that case disagreed that those 7 employees were wrongly terminated. But the ethics scandal caused by Mr. Miscamara's ramming through that decision delayed their reinstatement order by 6 months. People have been wrongly terminated. And as we know, that kills a union election if they're gone for 6 months. If the law required injunctions for temporary reinstatement, like our PRO Act would have, wouldn't those employees have been protected from these hijinks?
Absolutely. And if the law had required that, what happens is when an employer illegally fires employees, there's a tremendous chilling effect. It says to everybody else out there, support the union and I'll fire you as well. Going in immediately and getting an injunction would have showed 2 things. Would have showed, 1, the employer had acted illegally, and 2, the government was willing to stand up and protect workers and their rights. It would have encouraged them to go forward with the drive so that they had a voice on the job. As it currently stands, they can drag things out and dissuade people from unionizing by picking out a couple of scapegoats and illegally firing them.
Thank you very much. My time's expired. I yield back, Madam Chairwoman.
Thank you, Mr. Levin. Thank you so much. Mr. Johnson? See, they got all these names on here, and they don't have yours. That's my friend, Mr. Taylor.
Thank you, Madam Chair. Appreciate that. Ms. Miscara, did you want to respond to Mr. Levin? I know time ran short. It wasn't his fault, but just want to give you an opportunity to respond if you'd like to.
Yeah, no, I have no further response in relation to what he was asking questions about.
Okay, great. Thank you so much. So I just, I happen to represent a very affluent district that is, burgeoning, growing, lots of jobs coming. And as companies come to Texas, over and over again, I hear how important it is that Texas is a right-to-work state. And certainly in my 8 years in the legislature, it was really very important to us that we were a right-to-work state. It seemed to certainly attract a lot of jobs, high-end and low-end. Texas has certainly created a tremendous number of jobs. I think DFW recently reported they added 1 million people over the last decade. And a lot of them have come to my county, to Collin County. So you have a JD MBA from Wharton, is that right?
I do.
Okay, so you have me at a disadvantage.
In Penn Law School.
Okay, because the JD, I think, would be the law degree, right? So you're an attorney. I'm not. But I have read the Constitution, and in the Bill of Rights, there are 5 protected rights, right? Right for freedom of speech, freedom of press, freedom of religion, freedom to assemble, and freedom to petition. And I'm just concerned about this particular piece of legislation, H.R. 2474. It seems to have some things that might go contrary to our First Amendment rights, specifically the right to assemble and the right to speech. Can you speak to those 2?
Well, there are 2 things, I think, that create issues in relation to the First Amendment. One thing is that the bill prohibits an employer, or would prohibit an employer, from conducting workplace meetings in which the employer expresses its views with respect to union-related issues. And of course, an employer in relation to its employees has access to its employees when they are at work. A union attempting to organize has potential access to employees at every other time. And of course, employers have First Amendment rights just like anybody else. Corporations have First Amendment rights. So from that perspective, the bill implicates the First Amendment rights of employers. Secondly, the bill, as we have talked about, also would override the state laws that protect employees from being required in right-to-work states, from being required to make mandatory union agency fee payments. And the Supreme Court in the Janus case decided last year held that the First Amendment also protects compelled speech or a requirement that employees subsidize an organization with which they lack agreement. And so the Janus case, of course, dealt with First Amendment issues that arose in the context of public employment. Those same First Amendment issues have not been specifically addressed since Janus in the context of private sector employment, but this issue about compelled subsidizing an organization with which some employees do not agree certainly implicates potentially significant First Amendment concerns.
I appreciate that. Obviously, I would submit that Congress should not attempt to pass laws that are unconstitutional on their face. And certainly, you only have to go to the Bill of Rights to see those rights, and only the First Amendment to see those rights. Shifting over to something that I'm sure is important to you as an attorney, you're at a practicing law firm, attorney-client privilege. So attorney-client privilege is something that we understand as being very important, particularly within the context of the Seventh Amendment, the right to a trial by jury. And so as we think about that, does 2474, in your mind, violate some pieces of attorney-client privilege, which is so important to our judicial system?
Well, the bill would codify what was known as the Persuader Rule adopted by the Department of Labor several years ago, which has since been rescinded. But what the bill does, consistent with what the Department of Labor formerly required was, or it was in the process of being implemented and then it was abandoned by DOL, is that to the extent that employers consult legal counsel in relation to various union-related issues, that would then be subject to mandatory reporting. For purposes of the Labor Management Reporting and Disclosure Act, which is a significant change from current law and significant change from the way that the legal advice exception to the LMRADA has been interpreted.
And so that would really interfere with the attorney-client privilege. The ability for an attorney and a client to have free communication and discuss things, knowing that they're going to have to report that, right?
Well, and I think it would effectively limit access to counsel in many instances with respect to union-related issues.
Yeah, well, certainly limiting access to counsel strikes me as an un-American concept. That's just not right. I think we value that ability to have a functioning legal system.
Most lawyers would agree with you on that.
Well, I hope most on the dais do. With that, Madam Chair, I yield back.
Thank you, Mr. Taylor. No one else came. And now our distinguished chair, Attorney Scott.
Thank you. Mr. Trumpka, did you have a comment you wanted to make?
I most definitely did. I trust that Texas also wants to protect the free speech of employees other than just employers, because they can be made to go into these meetings and not say a word. If they do say a word, they get fired. That's not free speech. And he just erroneously told you it would prevent employers from having sessions like this. It would not. The difference it would be is they'd have to do it voluntarily. The workers would get to come if they wanted to and not come if they don't want to. The law as it currently stands, and as he proposes it, is that they must go, whether they want to go or not. They don't get a say in all of that. And I would like to correct a number of those erroneous things in written testimony after the hearing, Madam Chair, if that's permissible.
So ordered.
Thank you. Mr. Trumpka, could you tell me what the problem is that the Fair Share Agreement would solve?
Well, what happens with fair share is that you have an election and the union wins. And then they get a second bite at the apple. The ones that don't want to be in the union say, okay, the union won, majority rules, but you don't get to be, I don't have to be in the union, and you have to give me all the services that you give everybody else, and I don't have to pay. This bill would allow employers and employees to come together and say, that's not fair. If they want all the services, they also ought to have to pay a little bit of the tab. So it's like if you had a general election, an election for House of Representatives, and you got 52% of the vote, the other 48% could say, I don't recognize you. I get to be a different rule. And if you have any governance, I don't have to apply to it. I don't have to listen to it. And you have to give me all the services you give the other people.
And what kind of taxes under that scenario would you be paying?
What kind of taxes?
Yeah, you wouldn't pay taxes.
Well, you wouldn't under that scenario. I would opt out by saying, I don't recognize your new tax law.
Now, the fair share would cover just those services required by law. Would it cover things like annual cookouts and political activities?
No, it would not. We cannot charge for that, never have. Political activities are completely separate. And even if you don't have a right to work law, employees can opt out of the political part, the part of their dues that is used for political activity.
Now, let me ask another question. What's wrong with misclassifying employees as independent contractors?
Well, it takes away their ability to ever have a voice on the job. What an employer does is, there was one example where you had a trash company, and they classified the people that came in to pick the trash off the belt. They classified them as independent contractors, even though the employer, the original employer, determined the speed that the belt went. So they would never be able to have a voice with that employer and get the level of the speed, the conveyor belt. They couldn't negotiate to slow it down or to make the place more safe because they were, quote, the employees of not the employer, but an independent contractor. So it prevents them from coming together, organizing a union, and getting a voice on the job.
Would independent contractors be eligible for minimum wage?
For minimum wage?
Right.
Yes.
Independent contractors?
Well, no, they wouldn't have a minimum wage because they don't have an employer.
Right.
They're an independent contractor. So you're right, they would not be covered by it.
If there is an unfair labor practice, does the victim have to wait for, let me ask Mr. Pierce, if there's an unfair labor practice, does the victim have to wait for the NLRB to act, or can they act on their own?
They cannot act on their own. First, they have to wait for the NLRB to issue a charge. And then after the charge, it goes before an administrative law judge. And then after an administrative law judge, then it goes to the full National Labor Relations Board. After the full National Labor Relations Board, it can go to the Circuit Court of Appeals. After the Circuit Court of Appeals, they still have to go through an enforcement process then. So they say, yes, you must bargain, and then the employer doesn't bargain, so they have to go through much of the same thing again.
And let me ask Mr. Pierce one final question. What's the difference between a self-enforcing order and one issued by the NLRB under present law?
Under the present law, and thank you, Mr. Chairman, for asking the question, if a law is self-enforcing, then you don't have to go to federal court to get it enforced. It's immediately effective on the wrongdoer. Several other statutes provide that for wrongdoings and violations. The NLRA essentially is a car driving with a boot on it because it has to go and get to federal court each time it wants to enforce its remedies. So automatically it slows down the process, and victims are further damaged by the passage of time.
Is that it, Mr. Chair? Finish?
You'll back him.
As there are no more subcommittee members present, I now recognize the gentlewoman from Connecticut, Ms. Hayes, who was a former National Teacher of the Year.
Thank you, Madam Chair. I want to start off first by saying that I've spent my entire adult life as a proud union member. As a member of SEIU 1199, the Waterbury Teachers Association, the Connecticut Teachers Association, and ultimately the National Education Association. So I know both the power and the sense of empowerment that labor unions bring. In fact, in my year as National Teacher of the Year, there were 4 finalists celebrated at the top of their profession. 3 of those 4 finalists walked out of their classrooms in with their union brothers and sisters to negotiate wages, benefits, and most importantly, supports and resources for the kids in their classroom. All of those things are worth fighting for. And above all, unions give workers a seat at the table. So I get it. That's why I'm so frustrated when I hear stories around the country, and even in my home district, of workers who are actively being discriminated against or retaliated against for exercising their rights to organize. I've heard from Social Security Administration union representatives in Connecticut. They allege that the critical centers were closed in many states because they had high numbers of union employees. They allege that the Social Security Administration makes it more difficult for union reps to do their jobs and often targeted and retaliated against workers aligned with the union during personnel reviews, or when those workers requested leave or reasonable accommodations, they were denied. Meanwhile, their complaints to the National Labor Relations Board had gone unheard during this administration. Mr. Trumka, my question's for you. Are these complaints of employer retaliation common for workers who are union members or are looking to unionize, and have they increased in the most recent years?
We've seen the attacks, the number of things that they do. They have new threats now. They have the threat to move overseas. They have the threat to close down. They use the sweat sessions or the closed meetings, mandatory audiences more often now than they did before. They are longer, more intense, and they have a greater effect on workers. So we're seeing the law be violated more and more, and the ability to enforce it becomes less and less as it increases in intensity.
Thank you. In your testimony, you mentioned that workers who wanted to form a union often cannot talk with or meet with union representatives at their job. As I've mentioned, we've heard about this happening in my own district. However, employers are free to talk with employees. We heard a lot about those mandatory captive audience meetings. In fact, employers can require employees to attend these meetings. We also heard from my Republican colleagues on the other side of this committee that the PRO Act requires employers to provide private information to unions, which they claim unions could abuse or sell to third parties. Madam Chair, I'd like to submit a document that contradicts that argument. It's information. Thank you. It's information that the NLRB submitted to this committee in 2018. And it reveals that no employer has charged that a union has abused the voter information list since this procedure was updated in 2014. In fact, this document states that these lists are, this document shows that these lists are necessary to create parity during election campaigns, as employers already have this information to use with employees. Mr. Trump, again to you, how do these rules, which require that an employee share information and contact information with the union before an election, eliminate this double standard and make the process more fair?
Well, most of the time, only the employer knows who all of the employees are and where they work. So the new rule would codify an existing rule of the NLRB, and it would require them to provide promptly a voter list when an election is directed, including the name, the position, the shift, the work location, phone number, email, and physical address. That wasn't required under the old rules, but the NLRB now requires it. It is essential in order to be able to communicate with them, because remember, we're not allowed on the property. We can't go on, we can't talk to people. You may have to meet with them at a grocery store, any place else where you can get them. The most efficient place and the best place for them to be able to talk is in their home setting, at their home, so that you can have a real conversation with them.
Thank you. Mr. Pierce, I have 10 seconds. Do you think, we've heard a lot from especially Mr. Miscamara about banning captive audiences undermines employees' free speech right. How would this be protected, do you think, under this act?
Well, under this act, employees will have the freedom to freely discuss and choose not to participate in an employer's campaign. Employers with new technology have all the cell phones of employees or supply cell phones to employees, and they can send anti-union text to employees. Drivers can we have the cases where drivers have ride-alongs where the ride-along is giving propaganda to the employee continuously without the employee having the ability to say, you know, I don't want to hear this. And then the second piece of that is if the employee does say, I don't want to hear this, then they could be subject to retaliation. The technology and the control that the employers have it creates an imbalance with respect to employee access and a fair understanding of the election process.
Thank you. I remind my colleagues that pursuant to committee practices, materials for submission for the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing, preferably in Microsoft Word format. The material submitted must address the subject matter of the hearing. Only a member of the committee or an invited witness may submit materials for inclusion in the hearing record. Documents are limited to 50 pages each. Documents longer than 50 pages will be incorporated into the record by way of an internet link that you must provide to the committee clerk within the required time frame. But please recognize that years from now, that link may no longer work. Again, I want to thank the witnesses for their participation today, a very lively, energetic group of witnesses. We learned a lot, and we certainly appreciate your time. What we heard today is very valuable. Members of the committee may have some additional questions for you, so look out for them. And we ask the witnesses to please respond to those questions in writing. The hearing record will be held open for 14 days in order to receive those responses. I remind my colleagues that pursuant to committee practice, witness questions for the hearing record must be submitted to the majority committee staff or committee clerk within 7 days. The questions submitted must address the subject matter of the hearing. Before recognizing the ranking member for his closing statement, I ask unanimous consent to enter the following materials into the record in support of the PRO Act. I have letters from the United States Steelworkers, the International Union of Painters and Allied Trades, the AFL-CIO, the SEIU, and the UFCW, the Blue-Green Alliance, without objection. I now recognize the distinguished ranking member, Mr. Wahlberg, for his closing statement.
Thank you, Madam Chairwoman, and thanks to the panel for being here. It has indeed been a lively discussion. It's a worthy discussion. This is America. America's back. Michigan is back. I'm delighted about that. I'm delighted to see corporate entities coming back, building cars, products in Michigan again. It's a manufacturing state. It needs workers. It needs businesses in order to make it work together. My concern is that for anything that would stand in the way of continued expansion that purports to help workers or businesses and in the end cost jobs. We saw that happen in the downturn of the economy. I was here in 2007, 2008, and watched what took place in Michigan as it was decimated, as businesses left, and unions could not come up with what they promised to their employees, and we saw large corporations, specifically 2 of the big 3, go bankrupt, and we had to bail them out. Don't want that to happen again, because like Mr. Stas, that touches lives and families. What he's lived through, many, many people in Michigan lived through as well. So, while there needs to be reforms, there needs to be upgrades on the legislation as well as the agencies we put together to make sure they're working right and they're mobile, loose on their feet. We cannot walk away from the underpinning principles to undermine those principles that talk about the freedom that we have in this country. And so to take a bill like we're looking at today that eliminates right-to-work laws nationwide, regardless of whether the people of Michigan voted for that or not, is wrong. I say the unions earn it back. To stifle work of independent contractors, which limits workplace flexibility and opportunity, is wrong. Violate workers' privacy rights without them volunteering those pieces of information that could allow, yes, a union organizer to get their information and make those contacts. Voluntarily, great. Involuntarily, a violation of the rights of privacy. So we need to get it right. And Madam Chairwoman, I think this side of the aisle is willing to work on those issues. We're willing to work toward a solution that is indeed a compromise, that protects some of these key things that make America great, but more importantly, make our workers, our workforce, and our businesses great as well. So I commit to doing that, and I think this was a good start at talking about it. I hope it doesn't end here, but we continue in working toward solution. And before I end, Madam Chairwoman, I ask unanimous consent to submit letters in opposition to H.R. 2474 into the record from the following organizations: Associated Builders and Contractors, Coalition for a Democratic Workplace, Independent Electrical Contractors, International Franchise Association, National Association of Home Builders, National Restaurant Association, and National Retail Federation. I also ask to submit a letter from the Coalition for Workforce Innovation expressing concerns with the bill.
So ordered.
Thank you.
I now recognize myself for the purpose of making my closing statement, and as always, Mr. Wahlberg, the distinguished ranking member, is willing to work with me and with our committee, so this has been a great session today. We've heard your witness. I don't think that we heard you. We're going to try to connect the dots. Right now, they're not connecting. I now recognize myself for the purpose of making my closing statement. Thank you again to all of our witnesses for your testimonies today. Today we heard how the Protecting the Right to Organize Act can safeguard the fundamental human rights to organize a union by stopping employers from coercing and retaliating against their workers. Routine violations of workers' rights to organize suppresses wages and denies workers the opportunity to negotiate for their fair share of the wealth they create. We heard Mr. Trumka how the PRO Act can prevent abuse of workers' rights through penalties and holding coercive, captive audience meetings, making people sit and not move. We heard from Mr. Strauss on how difficult it is to organize a union in the face of vicious attacks. Mr. Strauss is one of many courageous Americans who stood up for their rights to organize a union, and he deserves justice under the law. Some of the stories I have heard and witnessed are deplorable. We heard from Mr. Pierce how the PRO Act would strengthen the National Labor Relations Board by reducing procedural obstacles and ensure that workers like Mr. Strauss receive swift remedies. As our witnesses have made clear, Congress must enact the PRO Act to deter violations of workers' rights and reverse decades of wage stagnation and income inequality. I thank my colleagues for a constructive help subcommittee hearing, and I yield back my time. If there's no further business, without objection, the committee stands adjourned. Thank you so much.